Jones.
Court will call 26 CF 105, State of Wisconsin versus Jordan Jones, extradition. Is he waiving?
It is my understanding that Mr. Jones does wish to waive his extradition rights. So if you sign this, you're signing saying that they can take you back to Illinois, that you're given ample rights to contest the hearing. You're not admitted to guilt on the charges at all, just that they can take you back, okay?
All right, appearances.
State appears by Assistant District Attorney Thomas Valerio. Good afternoon.
Good afternoon.
Jordan Jones appears in person in custody by Attorney Paul Frederickson from the Public Defender's Office. Good afternoon, Commissioner.
Good afternoon. Mr. Jones is here for an extradition initial appearance, and prior to the hearing, counsel did have time to meet with Mr. Jones outside the presence of all people present, and it's my understanding that Mr. Jones wishes to waive his right to extradition. Is that correct, counsel?
It is my understanding, Your Honor.
Is that correct, sir?
Yes.
You understand that you could request that a governor's warrant be issued, fight the extradition, and have bail set in this hearing, and you wish to waive all of that and actually go back, remanded to the custody of the sheriff's office to bring you back to the state of Illinois?
Yes.
Have you had any alcohol, drugs, or medications today?
No.
Have you had any, what grade in school have you completed?
High school diploma.
And do you read, write, and understand the English language?
Yes.
Did you have enough time to talk to counsel about waiving your right to an extradition hearing?
Yes.
And is it your, did anyone offer you or promise you anything to get you to waive that right to a hearing?
No.
I'll find that your waiver is knowing, intelligent, and voluntary. I will accept it. And I will remand you to the custody of the sheriff's department. We are adjourned on Mr. Jones' case. Good luck to you, sir.
Let figure of it be taken and then put on it.
It is answer. Next is DARIAN MIMS. MIMS. Oh, there it is.
We'll call 26 CF 107, State of Wisconsin versus DARIAN MIMS. Appearances.
State appears by Assistant District Attorney Thomas Valerio.
DARIAN MIMS appears in person in custody and by Attorney Paul Frederickson.
Attorney Frederickson, you met with Mr. MIMS prior to today's hearing to discuss his right to an extradition hearing or to waive that hearing. Has Mr. MIMS selected what he's going to do today?
Commissioner, he wishes to contest the fugitive warrant and ask that bail be set. He is eligible for public defender representation.
I have reviewed the extradition complaint. It states that he is wanted out of the state of Iowa for the crimes of burglary. State's position on bail.
Requesting a $5,000 cash bond in this case. As you mentioned, he's wanted out of the state of Iowa for count of burglary. It looks like that that offense was allegedly committed on or about November 12th of 2020 in Polk County. There, when I'm looking at the extradition paperwork, or excuse me, the arrest warrant, it indicates that no bond is authorized until the initial appearance. So that gives me concern as to his ties to the state of Wisconsin, whether they're substantial enough to ensure his return and contest the extradition.
Counselor.
Yeah, Your Honor, I would ask for a cash bail set at $500. I understand the state of Iowa's position. That's pretty typical on an extradition warrant. Mr. MIMS tells me that this is a charge predating 2020. He's actually pled, completed probation, and apparently they want him over some monetary fines. He's dealt with this warrant several times. They release him again. He is willing to appear in Polk County, Iowa on his own. He has informed me of that. $500, I think, is appropriate under these circumstances.
This extradition complaint tells me that he hasn't appeared and that they arrested him on this, tells me that he's wanted. So that's the only information I do have. So given all of that, I do believe cash bail is necessary for Mr. MIMS to be extradited if that's found to be appropriate to the state of Iowa. I will set cash bail in the amount of $3,000. We are adjourned in Mr. Mims' case. Good luck to you, sir. Talk to your attorney.
I've done probation. But if you're not saying change, I'm gonna ask for that. So would I have, so would I waive it? I just waive, just go ahead.
If you wanted to waive it, you could waive it right now.
Yeah, I just waive it, go.
You want to go through anything with them?
Yeah.
This is all the way down, so. All right, so. Which one do you sign the paper? You can be waiving your right to now. Maybe it's part of this. File other requirements. What the person in complaint. You sign this, you can send. So let's keep you until I sign, this is gonna put them on. Let them sign it. Yeah. That is totally, what I say. It's crazy.
We are still on the record in 26 CF 107, State of Wisconsin versus DARIAN MIMS. Mr. Mims had a bail set. He wishes to waive his right to extradition, so I will scratch all of the orders in regards to the bail. I will accept this waiver of extradition after asking some questions. Counsel, you met with Mr. Mims prior to the hearing and during the hearing in discussion of his waiving his right to an extradition hearing. Is that correct?
That is true, Your Honor. And we did talk about having bail set and what would happen if bail was set in an amount he couldn't afford. And so we had discussed this whole possibility prior to the hearing.
Mr. Mims, I watched you sign this document. You wish to waive your right to an extradition hearing and be remanded to the custody of the Sheriff's Department for return to Iowa. Is that correct?
Yes.
Have you had any alcohol, drugs, or medications today that interfere with your thinking? What grade in school have you completed?
GD and HSC.
So you read, write, and understand the English language?
Yes, ma'am.
Do you understand everything I have said here today?
Yes.
Do you need any additional time with counsel to talk about this extradition?
I just want, like I said, I done this time.
We have nothing to do with what Iowa says, sir. If that's all we got is what that complaint says.
That's weird. I was scared. It's the fourth time I've been there tonight, and each time they go, they let me go.
You'll need to speak with Iowa. All I'm telling you, all I know is that you're wanted there based upon this extradition complaint.
I've done this 2019. I've done this. I've completed probation.
You're gonna have to deal with Iowa. Do you wish to waive your right to an extradition hearing, sir? Do you wish to waive your right to an extradition hearing?
Yes, I'm waiting for this.
And has anyone promised you or threatened you in any way to waive that right? I'm gonna find that your waiver is knowing, intelligent, and voluntary, and I'm gonna remand you the custody of the Sheriff's Department for return to Iowa. Good luck, sir. Hopefully you get it taken care of.
Next is Aaron Brunstetter. Brunstetter. Bill.
No problem. Yeah, the bond is all vacated. We need just a second before we do Mr. Brunstetter.
I lived here for 2 years.
Okay.
My God. So it's hey, but.
Right. Got it. Okay.
Call 26 CF 113, State of Wisconsin versus Aaron Brunstetter. Appearances.
State appears by Assistant District Attorney Thomas Valerio.
Aaron Brunstetter appears in person, in custody, and by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We waive its reading. He would stand mute. The address is the best mailing address for this time, and he is eligible for public defender representation.
I have reviewed the criminal complaint as to counts 1 through 3, the misdemeanor charges. I do make a probable cause finding and enter a not guilty plea on Mr. Brunstetter's behalf. State's position on bail.
Commissioner, I'm recommending a $500 cash bond in this case. I'm asking that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription, and that he be banned from the 2800 block of North Sherman Avenue in Madison, Wisconsin, 53704. Mr. Brunstetter, to my knowledge, doesn't have any missed court appearances from his previous Dane County cases. What gives the state concern from a bail perspective is that he was on probation during the commission of this offense. That was from Waukesha County case number 24 CF 1393, where he was convicted of felony retail theft and was sentenced to 2 years of probation in September 2024. While he was on probation, he obviously commits the offense here. And what's noted by my DOC liaison is that it looks like he would, my notation is that he was absconding from supervision since November 21st of 2025. Incident date obviously occurs here on the 1st of January, so he was in absconder status when this offense occurred. He is also not helping himself from a bond perspective when he provides a false name to law enforcement. So I think that some cash is appropriate.
Counsel.
Your Honor, I'll ask for $250 cash. As opposing counsel noted, he is on a probation hold. So if he were to be released, he would have to be in good standing with probation. Specifically, they would have to provide some sort of services probably to him and reestablish any contact they might have lost. He has 2 children. They're 10 and 18 years old. He's been in Dane County for the last 2.5, 3 years. He's previously worked as a home health care aide, so he does have ties. He's indigent. I think $250 is appropriate. And I'd ask you to impose cash bail in that amount.
I will say cash bail amount of $250 based upon the information as provided by both counselors. I do believe that given the absconder status on probation, some cash bail is necessary to assure Mr. Brunstetter's appearance at court. I will set cash bail in that amount. I will also order as conditions that you not use or possess any controlled substances or drug paraphernalia without a valid prescription, and you are banned from the 2800 block of North Sherman Avenue in Madison.
Yeah.
Time limits as to the preliminary hearing, counselor.
We'll ask one be set, please. We'll ask a prelim be set, please.
Not waived.
Not waived.
Preliminary shall be timely set. We are adjourned to Mr. Brunstetter's case.
Next is Tyler REECE. REECE.
Just kidding.
Pollard. Pollard. There a Pollard in here? Roosevelt Pollard for a bail bond hearing.
Okay.
Bill Lawrence.
Court will call 24 CM 2856, 25 CM 256, 25 CM 257, 25 CM 1673, State of Wisconsin versus Roosevelt Pollard for bail hearings, appearances.
State appears by Assistant District Attorney Thomas Valerio.
Roosevelt Pollard appears in person in custody by Attorney Paul Frederickson. Good afternoon, Commissioner.
Good afternoon. We are here for bail hearings in regards to Mr. Pollard, state's position on bail.
Commissioner, you don't have information as to how the warrant was served. Do you know if he turned himself in or was he just picked up somewhere? If not, it's okay.
City of Sun Prairie, so I don't believe he did turn himself in.
Well, he's got 4 cases. I propose that you set bond in the amount of $250 in each case. That brings, he's had signature bonds in all of them. So I'm asking that each be converted to $250 with the same non-monetary conditions. My understanding is that out of county in Racine County, Mr. Pollard has bench warrants issued on October 19th, 2022. That bench warrant wasn't issued until, or it wasn't served until October 13th of 2023. And then in Dane County, he's had the bench warrant that we're here to talk about today issued on November 21st of 2025. and he was in warrant status until just recently, just yesterday. So I think Mr. Pollard also, it's also worth noting that he has 4 open cases right now, along with the forfeiture. They're property-related crimes, so that's fair to consider. So I think that a modest amount of imposition of cash throughout each of the cases is appropriate, given the history of appearance.
Counselor.
Thank you, Your Honor. I'd ask for signature bonds on all 4 cases, Commissioner. He did miss court. He acknowledges that. His father passed away and lived down south, let's say, in Arkansas. He got stuck down in Arkansas. He had an attorney at the time and should have contacted his attorney. He obviously made it back to Sun Prairie, where he resides. As opposing counsel indicates, these are nonviolent property crimes, really kind of small misdemeanor thefts, not the type that usually result in jail time, honestly. And these are from 2024 and early 2025. So although there was a warrant issued, there's a positive fact that there haven't been any new charges. He was arrested locally. He continues to live here where his siblings and extended family live. So I'd ask you to give him another chance to appear on a signature bond. I also should note, I'm not sure if Attorney Gonzalez is still his attorney of record. There hasn't been a motion to withdraw given the time period, but hopefully he can get in touch with his attorney and resume these cases quickly.
Given the number of cases, the missed court appearance, the outstanding case in another county with a missed court appearance and warrants issued, I believe cash bail is necessary to assure Mr. Pollard's appearance at future court dates. I'll go as low as I can in the amount of $200 on each of these cases and reinstate all non-monetary conditions. We are adjourned in Mr. Pollard's case.
Next, Jessie McShan.
Yep.
McShan. The other one.
Court call 26 CF 106, State of Wisconsin versus Jessie McShan, appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Jesse McShan appears in person in custody by Attorney Paul Frederickson. Commissioner, we have a copy of the complaint. We'd waive its formal reading at this time. He'd stand mute. The address on the criminal complaint is correct, and he is eligible for public defender representation.
I have reviewed the criminal complaint. As to count 3, which is a forfeiture, and count 4, which is a misdemeanor, I will enter a not guilty plea on his behalf after a probable cause finding. State's position on bail.
I apologize. I just need one moment. Okay. I'm recommending a $1,000 cash bond in this case. For conditions, I'm recommending that the defendant not operate a motor vehicle, that he not use or possess any alcohol, and that he be, I think the pretrial service folks are still backed up. So, oh no, they're taking folks.
No, they're not taking.
Okay. I would ask that you at least put him on the wait list for pretrial services for alcohol monitoring so that they can monitor him when they become available. So he's, Mr. McShan has a pending OWI 4th. I believe it's either in front of branch 13 or branch 7. But in that case, he's under conditions of not to operate a motor vehicle, not to use or possess any alcohol. He's violating those specific conditions of bond here, and he did it as well by picking up his prison level OWI offense, where he's now facing a presumptive 1.5 year incarcerated prison sentence. That's not even to speak about the OWI 4th exposure below. He's had failures to appear on October 5th of 2021 in case number 21 CT 315. In that same case, he had a failure to appear on September 20th, 2022 and March 17th, 2023. Given the fact that he picked up a prison level OWI while on bond, a first OWI 4th offense, and violating specific conditions of bond while doing it and having prior failures to appear, I think that the $1,000 cash is very appropriate.
Counselor.
Commissioner, I'll ask for a signature bond. I understand that there is a potential bond violation here that is alleged. Mr. McShane has not missed court in his OWI fourth offense. He has shown a willingness to appear in court. He has lived in Dane County for almost his entire life, for 30 years. And unfortunately, he is an SSDI recipient, so he cannot afford to post a $1,000 cash bond. That would essentially be a month's worth of his income. He is working with an attorney through the public defender's office already on his prior pending case. I think he would be very appropriate for pretrial services. Unfortunately, I know they're backed up at this time, but I'd ask for you to consider a signature bond today.
Given the pending case, given the multiple missed court appearances, 1 in 21, 1 in 22, and 1 in 23 cited by the state, that gives this court pause to and concern that Mr. McShane will not appear voluntarily. Additionally, these are mandatory prison sentences if convicted. It looks like his previous case is set for a plea and sentencing. Given all that, I do have concerns about Mr. McShane voluntarily appearing for court. I do believe some cash bail is necessary to assure his appearance. I will set it in the amount of $300. I will order that you not operate a motor vehicle during the pendency of this action and that you are not to possess or consume any alcohol. I will also do a pretrial services referral for the wait list. Time limits as to the preliminary hearing, Counselor.
At this point, we'd ask the prelim be set, Commissioner.
Prelim shall be timely scheduled. We are adjourned in Mr. McShane's case.
Should I?
Next is Victor ALVAREZ GASCA.
It's forfeiture.
Yeah.
Forfeiture, right?
Yes.
Fred?
Víctor Álvarez Gasca. Nombre es Revoked,
County, court will call 26 FO 92, Dane County versus Victor ALVAREZ GASCA. Appearances.
The county appears by Assistant District Attorney Thomas Valerio. The defendant, Mr. Victor N. ALVAREZ GASCA, appears in person, in custody, without counsel.
Mr. ALVAREZ GASCA, I have what some consider good news. The police department referred up criminal charges against you. The DA's office reviewed those police reports and decided not to charge you criminally. Instead, they've charged you with an ordinance. In this case, it's a county disorderly conduct. It is a municipal citation, similar to a parking ticket or a traffic citation. It is non-criminal. If this is the only case holding you, no matter what your plea is in this case, you're going to get released today. Sometimes this is a case that can get resolved today. What is the county's offer for a plea of guilty or no contest to this municipal citation?
Court costs only.
If you were to plead guilty or no contest to this municipal citation, I would assess court costs only of $114.50. If you want to plead not guilty, that's absolutely your right. And this case will get set for further proceedings. You do not have to pay that money prior to release. If you plead, you'll have time to pay. What is your plea to this municipal violation?
Guilty.
I'll find you guilty based upon your guilty plea. I'll assess court costs only of $114.50. It takes care of this ordinance violation and you'll have some time to pay. Good luck to you, sir.
Next is WYDEVEN.
Thank you, Fred.
Fred.
Ok, pórtese bien.
Roll call 26 CF 108, State of Wisconsin versus Ross Wydeven. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Ross Wydeven appears in person, in custody, and by Attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive its reading. He would stand mute. The address on it is correct, and he is eligible for public defender representation.
I have reviewed the criminal complaints. As to the misdemeanor charges, I do enter a not guilty plea after a probable cause finding. State's position on bail.
We're recommending a $2,000 cash bond in this case. We're asking that the defendant be banned from the Renew High Ridge Apartments, and that the defendant be banned from all of High Ridge Trail in the city of Fitchburg. It looks like, from what I can gather, Mr. Wydeven doesn't have any criminal record. He was charged with a criminal offense back in 2020. It looks like that was amended down to a county disorderly conduct. He has I don't know if this is still pending, he has a possession of cocaine count from in 25 CM 1168. I'm actually not sure if that one is still pending. I don't think we bothered to charge out the misdemeanor. Oh, it looks like we did charge out the misdemeanor bail jump. So he did commit this offense allegedly while he was on bail for 25 CM 1168. That's a bail consideration. But what I want to, I think he had one bench warrant issued on him that was in warrant status for maybe 2 days, and then it was canceled. So he got that taken care of. The reason why we're asking for a substantial amount of cash bail in this case is because these are several Act 3 eligible offenses that allegedly occur over the span of from December 25th of 2025 to January 4th of 2026. And Mr. Wydeven, on at least some of these occasions, is on video surveillance footage going from the apartment complex and Quick Trip. And I believe on January 4th, 2025, he is indicating, on at least one of the instances, I think it was regarding the December 31st burglary. Mr. Wydeven, according to page 6 of the criminal complaint, admits to being the primary driver of the suspect vehicle involved in the case. He admitted that he was at the leasing office at the time of the the New Year's Eve incident. And, that corroborates a lot of the other instances where Mr. Wydeven was seen allegedly burglarizing the location. He's specifically targeting Renew High Ridge. So under an Act 3 analysis, I think it's important to note that that location needs protection from Mr. Wydeven. And the public in general, I think, needs protection from this burglarious conduct. So I think that some cash is necessary, and I think the non-monetary conditions are appropriate.
Counselor.
Commissioner, we don't have any objection to the non-monetary conditions. He has no reason to be at those addresses at all. We would ask that you order a signature bond. I will note that we do have a public safety assessment that recommends a signature bond, that he has no prior criminal record, although apparently 2 prior criminal cases. I will note, and opposing counsel did note this as well, there is 1 prior failure to appear in the last 2 years. That's connected to the 25 CM case in Dane County. He missed court on August 19th. He called and cleared it up with the court, I believe, the following Monday. My calendar, I didn't look at the calendar for the exact dates, but that makes sense. On August 2022 or August 22nd of the same year, they withdrew the warrant. So he has 1 minor missed appearance. He took responsibility and came back immediately. He doesn't have any prior missed appearances. He's indigent and cannot afford to post $2,000. He's lived in Dane County for the last 29 years and has custody of his 8-year-old daughter who lives with him. So he has people that rely upon him that he needs to be out for. He doesn't have priors. He doesn't have a substantial history of missed court. These are his first felony allegations. So I think he is worthy of a signature bond, Commissioner.
Had this been Mr. Wydeven's first case, I would have given a signature bond, but it's his second case. And in the other case, he does have a failure to appear. He did correct that, so I don't believe as high of cash bail is necessary at the state is requesting. This is an Act 3 eligible offense, so the business is a consideration for protection in regards to that analysis. I don't want to see Mr. Wydeven sitting. However, I want Mr. Wydeven to appear at future court dates, and with that missed court appearance, and even though he did correct it and the number of offenses under the Act 3 analysis, I do believe some cash bail is necessary. I'm going to set it in the amount of $300. I'm going to order that you not be at Renew High Ridge Apartments, and you are banned from the High Ridge Trail in Fitchburg.
Okay.
Time limits as to the preliminary hearing.
We'll ask it be set, Commissioner.
The preliminary hearing shall be timely scheduled. We are adjourned in Mr. Wydeven's case.
Right, this way, sir. Next is Tyler Reese. Reese.
Yo.
Court will call 25 CF 2246, State of Wisconsin versus Tyler Reese, appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Tyler Reese appears in person in custody by Attorney Paul Frederickson. Commissioner, we have the complaint. We'd waive its reading. He would stand mute on the sole charge. We have an address to provide the court, and he is eligible for public defender representation.
And what is the address?
2824 South Bartels Drive, BARTELLS Drive, Beloit, Wisconsin, 53511.
I have reviewed the criminal complaint. It does allege one felony charge. State's position on bail.
Oh, sorry, 1 second. Okay. I have no objection to a signature bond in this case. I would ask that the defendant have no contact with KMA.
Any objection?
No.
I will then order a signature bond. I will order during the pendency of this action. You have no contact with KMA. Time limits as to the preliminary hearing.
We would waive the time limits, Commissioner.
Those are waived. A status conference shall be scheduled. Good luck with you, sir.
Yes, sign a bond.
JAVIN GIBSON. This way.
Court will call 26 CM 124, State of Wisconsin versus JAVIN GIBSON, appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Javin Gibson appears in custody in person and by Attorney Paul Frederickson. Commissioner, we have the complaint. We'd waive its reading. He would stand mute and the address is correct. He is eligible for public defender rep.
I have reviewed the criminal complaint. It alleges a single misdemeanor charge. I do make a probable cause finding and enter a not guilty plea on Mr. Gibson's behalf. State's position on bail.
I have no objection to a signature bond. I would ask the defendant be banned from the Aloha Inn, which is located on East Washington Avenue in Madison, that the defendant have no contact with Kaylin V, as in Victor. Their first name is spelled Kaelynn. And I would also ask that the defendant not use or possess any alcohol.
Any objection?
No objection. I will just kind of explain on the record. He indicated he has property at the Aloha Inn. I'm sure the sheriff's department can help him arrange that, or that's the advice I would give him in order to avoid running afoul of his no contact.
I will order that you receive a signature bond. I will order that you are banned from the Aloha Inn on East Washington Avenue and you have no contact with Kaylin B. If you have property you need to get, you need to contact the police department. You cannot go there without them. They will do a lethality assessment. If they believe it's safer to assist you in getting your property, then you will be able to do that. But otherwise you cannot go there. Okay, sir?
Yeah.
Good luck to you. We are adjourned.
I was gonna
Oh, and
add
no
too,
alcohol.
There's no way I could stay if I refuse this signature bond, because I'd basically be homeless. That might be the best way to do it.
I'm not going to give you legal advice, sir. You're getting a signature bond.
If I did decide to stay, then would I have to wait for the. I've done. I'll sign it. Figure it out. Okay.
Good luck to you, sir.
All right, yeah, thanks.
Next is Ariana Weaver. Weaver.
Court will call 26 EF 111, State of Wisconsin versus Ariana Weaver. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Ariana Weaver appears in person, in custody, and by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive its reading at this time. She would stand mute. She is eligible for public defender rep. And we have an updated mailing address.
What's that address?
2611 Hazelwood Court, Apartment 7, Madison, Wisconsin, 53713.
I have reviewed the criminal complaint as to count 1, the misdemeanor charge. I make a probable cause finding and enter a not guilty plea on Ms. Weaver's behalf. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant be banned from any farm and fleet location.
Any objection?
No.
I will then order a signature bond. I will order during the pendency of this action. You have, you're banned from all farm and fleet locations. Time limits as to the preliminary hearing?
Oh, sorry. She's asking the preliminary hearing to be set, Commissioner.
Shall timely be scheduled. We are adjourned in Ms. Weaver's case. Good luck to you, ma'am.
Next is Brianne Ripken for a bail bond hearing. Ripken?
Yeah.
What, it's.
Court will call 25 CM 1442, State of Wisconsin versus Brianne Ripken. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Brianne Ripken appears in person, in custody, and by attorney Paul Frederickson.
We're here for a bail bond hearing. State's position? Or do you want to hear defense?
Can you help me again, Commissioner? Did she get served in somewhere, or did she turn herself in?
Turn on warrant says Fitchburg, so she did not turn herself in.
Well, Commissioner, this is Ms. Ripken's first failure to appear, unlike some of the other folks we've had to talk to today on a bail hearing. I think let me just double check that. This is the only case she has open. I don't have a problem with you reinstating the signature bond on this one.
Assuming no objection.
No objection.
Ma'am, I will reinstate your signature bond in all non-monetary conditions. You made the court again. You're not going to get a signature bond. Got to make sure you make your court dates, okay? We are adjourned. Good luck to you. You're going to get a court date today. Make sure you appear.
Right now, you.
She will.
No, I'm not, but yeah.
Next is Christopher Bullins, appearing via Zoom.
Court will call 26 CF 117, State of Wisconsin versus Christopher Bullins. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Christopher Bullins appears in custody via video. It looks like he's on mute, and by attorney Paul Frederickson appears in the courtroom. Mr. Bullins, can you hear us? Can you put a thumbs up if you can hear us in the courtroom? It looks like it. Did you get a copy of a criminal complaint today? Could you put a thumbs up if you do have a copy? Okay. If you have a copy of the criminal complaint, we waive its reading at this time. He would stand mute. I don't have information about eligibility. However, he is represented by Public Defender's Office on a separate case.
I have reviewed the criminal complaint. It does allege 2 felony charges. State's position on bail.
I'm recommending a $5,000 cash bond in this case. I'm asking for non-monetary conditions that the defendant have no contact with Travis V. or Deputy Larissa C. Their first name is spelled Laurissa, except in their official capacity as a law enforcement officer. This case involves Mr. Bullins returning to the Dane County Jail after he had his prelim in Dane County Case 25 CF 2930. That's a kidnapping case where he's sitting on a $40,000 cash bond. In this matter, he allegedly beats up another inmate over what appears to be a ramen noodle packet. He's then transferred to administrative confinement. And while in that administrative confinement, he fashions 2 shivs out of toothbrushes, which I'm assuming is where the illegal article is coming from. It's our understanding he has no substantial ties to the state of Wisconsin. He was just released from prison and allegedly told the victim in his open case that he doesn't care if he goes back to prison. This is an Act 3 eligible offense. What I just want to make sure of. Okay. So I think it's fair to keep that in consideration. I think that substantiates the significant cash bail request.
Counselor.
I'll ask for 1,000. He's already on a $40,000 cash bail. He can't hold. He's indigent. $1,000 seems appropriate considering he was already confined at the time and is unlikely to be released anytime soon.
Given the violent allegations and the potential lethality of those toothbrushes as described in the criminal complaint, these are Act 3 eligible offenses with the battery charge and the underlying charge, which has him in custody. I do believe cash bail is necessary to assure Mr. Bullins' appearance at court date. I will set it at the amount of $3,000. I will order he have no contact with Travis V. or Deputy Larissa C. unless in her official capacity in law enforcement. Time limits as to the preliminary hearing, Counselor.
Not waived. The last one be set.
Those are not waived, and a preliminary hearing shall be timely scheduled. We are adjourned in Mr. Bullins' case.
Next is Shantiera Williams. Williams.
Court will call 26 CF 115, State of Wisconsin versus Shantiera Williams. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Ms. Williams appears in person in custody and by Attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive its reading. She would stand mute. She's eligible for public defender representation and state interest. And then we need a new mailing address. She'll tell the court.
5021 Pendleton Drive.
5021 Pendleton
Yes, ma'am.
Drive that's in Madison,
Yes, ma'am.
apartment 210. Do you know the zip code offhand?
I think, yeah, I do 53718.
All right, thank you for that. I have reviewed the criminal complaint. It does allege 1 felony charge. State's position on bail.
I'm recommending a $1,000 cash bond in this case. I'm asking that the defendant not operate a motor vehicle as a condition of her bond. This case involves a situation where law enforcement was dispatched to a large group fight. Law enforcement observes, I believe, what ends up being Miss Williams' car, being the only one not pulling over, while the other suspect vehicles were pulling over. Instead, Miss Williams increased her rate of speed and fled from the traffic stop. Law enforcement attempted 3 traffic stops during this same course of conduct where their lights and sirens were activated. Miss Williams was speeding for some of those attempted stops. She was paying attention to some of those traffic lights, but then she went through a light while the pursuit occurred. After the pursuit ended, law enforcement was driving in the area, noticed her at a Citgo gas station, hiding behind the driver's side door while at the pump, and then she started to walk into the gas station. My understanding is that she was on probation. Second. At the time of this incident. Oh, okay, yeah, she was on probation that was in Waukesha County case number 22 CF 1569. She was convicted of possessing with intent to deliver between 5 and 15 grams of cocaine. She was sentenced to 3 years of paper in July of 2023. So she was on paper when this happened. There was also a failure or bench warrant issued on October 31st of 2022 in that Waukesha County case I just mentioned. She resolved it though. It ended up being canceled about a month later, but it's still there. So I think given the fleeing conduct here, the fact she did it on paper, I think suggests that she's a bail risk and that some cash needs to be applied.
Counselor.
Commissioner, I would ask for a signature bond. Ms. Williams does live in Wisconsin. She's lived here her entire life. She has a 4-year-old that she's responsible for taking care of, and would like to get back to her parents, siblings, and entire extended family are here as well. I would note that although the allegations are a flee and elude, the speeds noted, at least if you believe what's in the criminal complaint, are in the 45 to 55 mile an hour range, not the high speed sort of dangerous fleeing we often see in the community. She talks about kind of some confusion associated with being pulled over. Again, that's if you believe what's in the criminal complaint. So I think this is a mitigating fleeing and eluding. I think that she's worth the risk on a signature bond. She is currently on probationary supervision and would have to coordinate with her probation agent, her release. And I suspect that that would mean additional rules if she were to be released.
In reviewing the criminal complaint, there are multiple attempted stops, so it's not just a confusion as stated by Ms. Williams. The fact that she's on probation and that she has prior missed court appearance and is failing to allegedly stop for law enforcement does give me pause to believe Ms. Williams will appear on her own behalf. There doesn't seem to be an extensive record for Ms. Williams. I do believe $300 cash bail is necessary to assure your appearance at future court dates. Order as a condition that you not operate a motor vehicle. Time limits as to the preliminary hearing.
For now, we'll ask the prelim be set.
Preliminary hearing shall be timely scheduled. We are adjourned in Ms. Williams' case.
Next is John Asher, hearing via Zoom.
Sorry, I missed that.
Evans.
No, I did not order that. Who are we doing? I'm sorry.
Evans.
Thank you. Court call 26 CM 126, State of Wisconsin versus John Evans. Appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
John Evans appears via video conferencing and by attorney Paul Frederickson in the courthouse. Mr. Evans, do you have a copy of the criminal complaint?
Yes, I just received it.
Okay. We would waive any further reading. He would stand mute. I do not have information about whether or not he's eligible for public defender representation. I believe the Dane County Jail is probably the appropriate address at this time.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Mr. Evans' behalf. State's position on bail.
I'm requesting a $500 cash bond in this case and a condition that the defendant have no contact with Diana F. Their first name is spelled Dianna. This is an incident where between December 31st and January 1st of 2025 and 2026 respectively, Mr. Evans calls the alleged victim's number 130 times from the jail in contradiction with, I believe, a court order. I think this was an instance where Mr. Evans was given 940.47 admonishments. I'm just trying to see what my notes say in the underlying case. Yeah, so it looks like on January 6th, he was given those admonishments. No, that's not right. I think he was given admonishments in the, I apologize for that. He was given admonishments in the 25 CF 2917 case on December 30th of 2025. So immediately after receiving those admonishments, he allegedly calls 130 times the same victim. So he's violating allegedly a court order. I think that gives me pause from a bail perspective. So I think some cash is necessary.
Counselor.
I'll ask for $250 cash. He's already being held on $1,500 and has no ability to post. These are non-violent offenses. I think $250 is appropriate.
Given the prior cash bail that he still remains in custody, given the allegations, I do believe that $250 cash bail is necessary. I'll order no contact with Diana F. I will again order that under 940.47, that knowing and malicious prevention or dissuasion of any person who is a victim has occurred or is likely to occur, so that no contact is consistent and contingent upon this case as well. So whether or not you post bail, whether or not you get out and you can be charged with new offenses, you must have no contact with Diana F. no matter what. You can't call, write, text, message. It does not matter if you sign a bail or are released. I'm ordering this under 940.47. No contact.
Yes.
We are adjourned.
We went to court for this, like, this another charge?
Yep, no contact, sir. That's what you're alleged to have violated.
I already went to court for, I can show you the papers and everything.
No, we're done, sir. We're setting that bail. You can get yourself an attorney at the public defender's office. Make sure you apply as well on the other case. But for today's purposes, I've set an additional $250 cash bail on this case and entered a not guilty plea on your behalf. We are adjourned.
Next is Marquetta Wortham. So. You're probably not interested.
Court will call 26 CF 112, State of Wisconsin versus Marquetta Wortham. Appearances.
State appears by Assistant District Attorney Thomas Valerio.
Marquetta Wortham appears in person in custody by attorney Paul Frederickson. Commissioner, we have a copy of the complaint. We'd waive its reading. She would stand mute. She's eligible for a public defender, and we do need to correct the mailing address when you're ready.
What's that address?
1125 Chicory Way, Sun Prairie, Wisconsin, 53590.
They're in our apartment. I have reviewed the criminal complaint as to the misdemeanor charge. I do enter a not guilty plea after a probable cause finding on counts 3 and 4. State's position on bail.
I have no objection to a signature bond. I would ask the defendant be banned from all farm and fleet locations.
Any objection?
No.
I will then give you a signature bond. I will order that you are banned from all farm and fleet locations. Time limits as to the preliminary hearing.
She's asking the prelim be set, Commissioner.
Timely preliminary hearing shall be scheduled. We are adjourned in Ms. Wortham's case.
All right. Next is Cecilia Goldsberry. Goldsberry. What?
Court will call 26 CF 109, State of Wisconsin versus Cecilia Goldsberry. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Cecilia Goldsberry appears in person in custody and by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive its reading. She would stand mute. The address is correct and she's eligible for public defender representation.
I have reviewed the criminal complaint. I do make a probable cause finding as to counts 2 and 3 and enter a not guilty plea on Ms. Goldsberry's behalf. State's position on bail.
I believe this is a case where the victim would like to make a statement. Can we just give them the opportunity if they would like to make a statement?
Sure, they aren't listed. If you're here on the Goldsberry matter, please unmute yourself.
Hi,
Please, hi, please state and spell your name for the record.
Yasmin Yazmine
And this is your opportunity to tell the court what you think I should do in regards to setting bail.
I feel like you should give her a second chance. There's been a lot of different changes going on as far as like death and etc. I'm willing to still have contact with her, but at this time, I think we should just keep our distance. But a second chance should be given to her.
Thank you, ma'am. The court will take your statements under advisement when setting bail here today.
Okay, thank you.
State's position on bail.
So I'm recommending a $500 cash bond in this case. For conditions, I'm asking that the defendant have no contact with Yasmin H. This is a situation, my understanding is that Ms. Goldsberry and Yasmin H were engaged in a dating relationship. They were talking about some type of relationship issue. And it's alleged that Ms. Goldsberry gets upset. Through the reports indicate that Miss Goldsberry grabbed the victim by her neck with both hands and squeezed, causing her to lose breath. Miss Yasmin informed law enforcement or individuals at the hospital that her vision was starting to black out. She indicated she did not lose consciousness, though. The victim also stated that the defendant punched her multiple times. This is corroborated when law enforcement gets to the scene. They note that Yasmin H has I think EMS notes that it's an actively runny nose. By the time cops get there, I think the bleeding has stopped and it's dried on her face. And then this is also a situation where a third party intervenes. So it's not just Miss Goldsberry and Yasmin H. Someone else is also seeing this alleged conduct. My understanding is that Miss Goldsberry's mother was in the other room, hears a physical fight, goes in and has to break them up. You should also know that there were injuries to Yasmin H's neck that were consistent with a strangulation event. So I think the no contact, at least at this time, is appropriate, Commissioner. Miss Goldsberry does have, this is an Act 3 eligible offense. Miss Goldsberry was previously convicted of misdemeanor battery in 24 CM 2039. That was against a different victim. But that's still an act, what's termed as a violent offense under our Act 3 analysis. And so I think given that, and given the fact that we're looking at a stronger case as far as strangulations are concerned, I think that some cash is appropriate here.
Counselor.
Commissioner, I'll ask for a signature bond. I haven't heard about a history of missed court appearances. Miss Goldsberry is fine with having a no contact with the alleged victim at the time. I think it's appropriate. She's lived in Dane County all of her life and currently resides with her parents, so she does have a support system here. I haven't heard that she's a risk to not appear to court. These are felonies, but they are lower level felonies. She doesn't have an incentive to not appear. In fact, things will go much better for her if she does appear. She's indigent. She's eligible for public defender representation and does not believe she can post $500 at this time. I think a $500 cash bail would be essentially keeping her in custody based on her poverty. So I'd ask you to consider a signature bond because unlike some of the other ones today, we don't have her on a PO hold. We don't have her breaking a bond. This is a solo case. I think she deserves a chance on a signature bond.
I haven't heard anything in regards to Miss Goldsberry missing court. This is Act 3 eligible. However, the states or the courts have the opportunity to hear from the victim who believes that Miss Goldsberry should be given a second chance, but kept her distance. I am going to give Miss Goldsberry the opportunity to appear on her own recognizance. I will give you a signature bond, no contact whatsoever with Yasmin H during the pendency of this action. No calling, writing, texting, messaging, no contact whatsoever. Time limits as to the preliminary hearing.
Just let me ask, Commissioner. He would waive the time limits, Commissioner.
Time limits are waived. A status conference shall be scheduled. Good luck to you, Ms. Goldsberry. Thank you, Ms. Yasmin H.
You're welcome.
Next is Gerald Search appearing via Zoom.
Court will call 26 CF 104, State of Wisconsin versus Gerald Search appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Gerald Search appears in custody via video and by Attorney Paul Frederickson in the courtroom. Mr. Search, do you have a copy of a criminal complaint?
Yeah, I just not received it though.
Okay. We have a copy of the complaint. We'd waive its reading. He would stand mute. I believe the address. We haven't had an opportunity to interview him, so I'm not sure if the address is correct, Commissioner.
Mr. Search, they've got a mailing address for you at 615 East Washington Avenue. Is that your best mailing address?
No, it's not.
What's your best mailing address, sir?
I have almost. You're on.
Okay, well, you need to update the court as best you can, because right now you've got that 615 East Washington Avenue address listed, and you want to make sure you get notices of your next court dates. I have reviewed your complaint. It alleges one felony charge, state's position on bail.
I'm recommending a $1,000 cash bond in this case. I would ask as a condition that the defendant comply with the sex offender registration requirements. So out of the way, I think it's worth mentioning, though I don't think it's that they're rather old. It looks like there were bench warrants issued on June 21st, 2019, April 1st, 2019, and February 25th, 2019. as I mentioned, those are older. I think they're worth mentioning though, because like, looks like one of them, one of the cases involved with those bench warrants, I think was his child pornography case. And I'm betting that's probably the case that caused him to be on the sex offender registry in the first place. Regardless, here in this case, he's been non-compliant with SORP requirements since June 4th of 2025. He let his GPS die. He's not been in contact with his probation and parole agent. And when he was at the hospital, as noted in the reports, he told staff, quote, "My PO is going to put me back in jail," end quote, and then left the hospital before his agent could have in-person contact. Given the, albeit later or older, failure to appear history and his conduct as it pertains to this case, I think that cash is necessary to appear for court.
Counselor.
Your Honor, I'll ask for $250 cash. It's a non-violent status offense, but because inherent in this particular offense, there is sort of indications of non-compliance. I can understand why some cash is appropriate. I would just note for the record, without speaking to the specific facts of this case, it is exceedingly difficult to remain on the sex offender registry and comply with requirements when you're unhoused, which is what it sounds like Mr. Search has been going through. It is a very difficult, sometimes onerous process. That doesn't mean he doesn't have to, but it is a very difficult thing to keep up with when you are on house. So I think $250 cash is appropriate at this time. From what I understand, there's a PO hold anyway, so there may be other consequences coming as well, Commissioner.
Given the length of time that the violation is alleged to have occurred, given the conduct, which once he knew his probation agent was going to appear, he left the hospital. And those avoiding tactics that were alleged to have occurred by Mr. Search, I do believe some cash bail is necessary. I will set it in the amount of $250. Time limits, Counselor.
At this point, I just asked that the prelim be set, Commissioner.
Preliminary hearing shall be timely scheduled. We are adjourned in Mr. Search's case.
Is the court denying the?
Oh, I will also order that as a condition, you comply with all sex offender registry requirements.
Okay, thank you.
Next is Haley Begettings.
Protocol 26 CF 110, State of Wisconsin versus Haley Begettings, appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Haley Begettings appears in person in custody and by attorney Paul Frederickson. Is that your best? Yeah. Okay. We have a copy of the complaint. We'd waive its reading at this time. She'd stand mute. The address is the best mailing address. At the time, Ms. Spaghetti said she did not want public defender representation. My understanding is that she is going to apply, does want representation.
I have reviewed the criminal complaint. I do make it, it's one felony charge, state's position on bail.
I have no objection to a signature bond. I would ask that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
Any objection?
No.
I will then give you a signature bond, Ms. Spaghetti's. I will order that you not possess or consume any drug paraphernalia or controlled substances without a valid prescription. Time limits as to the preliminary hearing.
Your Honor, we'd waive the time limits.
Time limits are waived. A status conference shall be scheduled. We are adjourned in Ms. Spaghetti's case.
Okay. All right, ready this way.
We are adjourned. Thank you, everyone.